Namaskar, myself Anil Kumar, and today we are going to discuss on COPRA, Consumer Protection Act. The background of this act is the Consumer Protection Act 2019 was notified on 9th August 2019 but came into force from 20th July 2020 to provide the timely and effective administration and settlement of consumer disputes. After the act came into force, it was observed that the existing provisions related to pecuniary jurisdiction of consumer commissions were leading to cases which could earlier be filed in national commission to be filed in state, and the cases of state into district. This caused a significant increase in workload of district commissions, leading to rise in pendency and delay in disposal of cases, defeating the very object of securing speedy redressal to consumers as envisaged under the Act. Looking into it, central government had notified the consumer protection jurisdiction of district commission, state commission and national commission rules 2021 on 30th December 2021. There are 6 consumer rights that have been defined in the Act, which are given as under: right to safety, right to be informed, right to choose, right to be heard, right to seek redressal, right to consumer education. First of all, the definition of consumer. What is consumer? A consumer is defined as a person who buys any product or avail a service for a consideration. It does not include a person who obtains a good for resale or a good or service for commercial purpose. What are the new additions in COPRA? It covers transactions through all modes including offline and online, through electronic means or teleshopping or multi-level marketing or direct selling, e-filing of complaints, that is e-Dakhil portal started by central government, establishment of CCPA, Central Consumer Protection Authority, and modifications in claim limits of different forums. Now we are going to discuss about redressal mechanism. The Consumer Protection Act defines 3-tier redressal mechanism, quasi-judicial machinery at national, state and district level. The revised pecuniary jurisdiction for entertaining consumer complaints where value of the goods or services paid as consideration shall be up to, at district commission, that is district forum, up to 50 lakh rupees, state commission above 50 lakhs and up to 2 crore, and in national commission above 2 crores. In continuation of redressal mechanism, the complaint shall be filed within 2 years from the date on which cause of action has arisen. This would mean 2 years from the date the deficiency in the service or defect in goods has arisen or detected. This is also known as limitation period for filing the complaint. A complaint should be in writing, can be filed offline or online through e-Dakhil portal, and the URL is http://edakhil.nic.in. A complaint can be presented by the complainant in person or by his agent. It can even be sent by registered post along with the court fee. Normally, 3 copies of the complaint are required to be submitted, out of which one retained for the official purpose, one is forwarded to the opposite party, and one is for the complainant. The new Act provides for simplifying the consumer dispute adjudication process in the consumer commissions, which includes empowerment of state and district commissions to review their own orders, enabling a consumer to file complaints electronically and file complaints in consumer commissions that have jurisdiction over the place of his residence, video conferencing for hearing, and deemed admissibility of complaints if the admissibility is not decided within the specified period of 21 days. The new Act stipulates that every complaint shall be disposed of as expeditiously as possible, and endeavour shall be made to decide the complaint within a period of 3 months from the date of receipt of notice by opposite party where the complaint doesn't require analysis or testing of commodities, and within 5 months if it requires analysis or testing of commodities. The new concept, mediation, introduced in judicial mechanism. Alternate dispute resolution mechanism of mediation has been provided in the new Act. This will simplify the adjudication process. A complaint will be referred by a consumer commission for mediation wherever scope for early settlement exists and parties agree for it. Mediation will be held in the mediation cells to be established under the aegis of consumer commissions. There will be no appeal against settlement through mediation. As per Consumer Disputes Redressal Commission rules, there will be no fees for filing cases up to 5 lakh rupees. The other informations related to COPRA: appeal can be initiated from one forum to next higher forum within 45 days from the date of order. Final appeal will lie before the Supreme Court of India. Punishment: imprisonment not less than 1 month, which can be extended up to 3 years, and fine from 2,000 rupees to 1 lakh rupees, 10,000 rupees. New Act also introduced the concept of product liability and brings within its scope the product manufacturer, product service provider, and the product seller for any claim for compensation. The Act provides for the punishment by a competent court for manufacture or sale of adult and spurious goods. The court may, in case of first conviction, suspend any license issued to the person for a period up to 2 years, and in case of second or subsequent conviction, cancel the license. In case of misleading advertisement, CCPA may impose rupees 1 million penalty and imprisonment of 2 years, and for subsequent offence it may impose rupees 5 million penalty and imprisonment of 5 years, and product prohibition up to 1 year, and for subsequent offence it may be extended for 3 years. Hope you have learned the modifications or changes of COPRA 2019 amendment in 2021. Happy learning and thank you.